A very good evening to all, and thank you, Shuklaji. I thank Taxmann for giving this wonderful opportunity to bring all of us together on today evening to discuss one of the most interesting and exciting topic, litigation arena and GSTAT. So, friends, are we ready? Yes, let's go on. Drafting is the first step in litigation, and when an order is signed, it's the last. So, friends, the entire journey in between falls from beginning from notices to adjudication orders, first appeals, second appeals, rightly said that tribunals. Now we all are aware that GSTAT president has been appointed, and in few months' time, the GSTAT tribunal will also become functional. But friends, going through this long journey, we must pay attention and be heedful to all the replies which we have made to the revenue departmental authorities. Why is it so? Friends, please understand that each notice has its own weightage and value. Value not in the terms of amount, but materiality. At which stage, which notice will get resolved, that is very important to judge, and to make this judgment is nothing else but called as litigation strategy. The notices once issued will go up to the adjudicating officer order level. Taxpayer can go to first appeal, second appeal, if required, High Court, Supreme Court, and this is the hierarchy. Friends, nowadays mostly taxpayers are in a very hurry to get all the notices resolved at the first adjudication level itself. But please understand the practical requirements and the mindset of the taxpayers needs to go through a change, at least in under GST. We all are aware and we see in day-to-day practices that many times some of the valid points may not come as a favor in the order which the taxpayers are getting, and hence we need to take a step further and reach the first appeals. So with this preface, we'll start our today's session. The points to be covered, the pointers have already been distributed earlier. Still, we'll take it up as we go on. My humble request to note down your questions and queries as discussed by the organizing team. We'll take it up at the end. And today's session has been divided in 3 different parts. So if possible, all should attend it fully to get the in-depth and get the full value of the same. So let's begin. A warm-up match. IPL season is over. T20 ICC World Cup has started. Then why this wording's a warm-up match? Friends, in taxation litigation area, from notice aspect itself, the journey begins. So we all need to be cautious in replying to the notices at the first level, because that will make the base on which we can strengthen or weaken the case at the tribunal level itself. Here I would like to insist and mention about section 160 subsection 2 of CGST Act, wherein it states that if a taxpayer needs to raise a question in regards of technicality or merits of the notice, they need to mention it in the first reply in itself. If not done so, then later on that right goes away. So friends, the first preliminary reply is utmost important. Like in case of a patient wherein the surgeon diagnosis the disease in the first OPD checking. So it is just not that to consider a notice as a random normal notice, give up some writing, write a forwarding letter, give up some submissions, and just wait and watch and see what next unfolds, how department or revenue will take it forward. Next, aim of notice. Before we move to our discussions of GSTAT, we need to understand this background to get the grasp of this grassroots level, because on this order itself, the order will be carried away till tribunal and then will again be fighting for justice. Friends, please bear in mind, the aim of notice is not to directly tell or detect that the taxpayer has done something wrong. Section 59 under CGST Act is about self-assessment. So the returns which are filed, the annual returns which are filed, government will be and is under the assumption that the taxpayer has done his own self-assessment properly and accurately, and in that scenario, he or she or they have filed their GST returns. So friends, the aim of notice is just to convey that a different opinion, a different viewpoint out of which the taxpayer has taken in his returns or in his books is possible, and to find out the future status of this viewpoint, a notice is issued. We have already discussed, we need to be cautious and aware that at which level, which notice can get justice and get resolved. So we need to make a litigation strategy for the same from the beginning itself. How and what to do, few of the aspects will be covered in today's session itself. So stay tuned. Approach. We already discussed on the mindset of the taxpayers. As professionals, as consultants, we need to make them aware that gone are the days you may not get justice at the first forum, first table itself. You need to wait, you need to follow the procedures of law and apply to the higher forum, where you get a more better outcome and a fair trial which every taxpayer seeks. And more so, it is a constitutional right given to all the citizens of India. Approach, can do approach, yes. Based on merits and facts of the case, taxation litigation is possible. We should explore that area and see how best can we give our services to the taxpayer and the SSE who has been receiving some notices, adverse orders, and is not happy with the outcome he has got till now from the department. Friends, the legal taxation framework, as we are aware, at executive level, when the GST Act was coming up, the model GST law had been brought in. So at executive level, the authorities, they prepare the draft structure of the law, provisions and the rules they say. Legislative, the parliament has the legislative power to bring the law into force, bring the bill into force and enact it upon the Indian territory. Third aspect is judiciary, wherein the role of tribunal, which is a quasi-judiciary, High Court, Supreme Court, turns up for interpretation of tax disputes, interpretation of various taxation intricacies, and give a fair and proper trial to the taxpayer. Background of appellate tribunals. Being the topic of GSTAT, we have just covered regarding CESTAT and CESTAT. I mean, we are focusing on indirect taxation itself. At present, CESTAT is functional, which was earlier constituted as CESTAT. This is just little history. We'll quickly go through the same and then move forward to other vital topics like drafting and rule of law. CESTAT, we are aware customs excise service tax cases are being dealt into. New Delhi as its headquarters and 8 benches are there of CESTAT. A judicial and technical member presides over each bench and they decide. At times there is also a single bench, single member. GSTAT, which was due to be formed, has got its approval, and retired Justice Sanjay Kumar Mishra sir has been appointed as first president recently. Now, with his appointment begins the functionality of GSTAT, which will be a crucial body in resolving GST related issues. Government has already notified principal bench located at New Delhi and 31 state benches at various locations. So friends, the thing to mark over here is that under CESTAT, there were total 9 benches. Under GST, there are 31 state benches. And in most of the states, they'll be presiding over 2 to 3 locations per state as per the size and requirement of the state taxpayers. So friends, one of the subtopics of today's session was opportunities under GST litigation. With the numbers of benches and the way the notices are being issued, orders are coming up, we can gauge and make a sense that how big the opportunity under GST litigation area will come up. Earlier there were 9 benches, now there are 31 benches overing to many locations in itself. So friends, the number of cases being piled up which will be applied, taken over, will be in huge quantum. Process for appointment for other members is already under process. Benefits from formation of GSTAT, low pendency, faster disposal of cases. For taxpayers who have been aggrieved from first appeal, they'll get an opportunity to move to second appeal. At present, as the tribunal has not been constituted, taxpayers didn't have a choice but just to go and knock the doors of the high courts of their state and seek justice. Second, swift, fair, judicious, effective resolution to GST disputes and reducing burden on high courts as well. Friends, another misconception, we need to educate our clients, taxpayers, that to knock the doors of high court is a lengthy process, it's very costly, but in turn it is not so. And in many cases, we have seen that remains the only option wherein quicker justice can be availed. So we all are aware that many writ petitions have been filed with various high courts seeking removal of freezing of the bank accounts, e-waybill matters, so on and henceforth. Advantages of approaching the tribunal and how it will function. As we all are aware, it is an appeal mechanism. Once the order is received from the first appeal, Commissioner of Appeals, if the taxpayer is aggrieved, they can approach the second appellate authority, that is the GSTAT tribunal. Tribunal members having specialist knowledge and experience in this aspect, a fair and consistent decisions will be made. Going to tribunal, one needs to follow less formal procedure aspects as compared to high court. So it is easy for the party and the consultant itself to knock the doors of tribunal. Next point, it will be cost effective. We've already discussed it. Faster resolution. The tribunal has been set up to hear cases just on this aspects. So you've got a quicker date, faster date, less hearings. You'll get your judgment and the order. Specialized adjudication. Tribunal members, those will be experts. They'll have deeper understanding related to GST disputes, taxation matters, and they can help to give more informed and fair decisions as well. Structure. GSTAT is a specialized authority formed to resolve GST disputes. It is second appellate. Its internal structure would be as a national bench based at New Delhi. President will head it. Judicial member, technical members, one from state, one from center. That's the bifurcation they have kept. This is the structure of the technical and judicial members. Some eligibility criteria which have already been mentioned in the Act. And friends, it is good to know that CAs and advocates were also invited to apply to become the members. So let's see how far it goes on and how many of them can become members and sit on the other side of the table. Rules, powers, and duties. Basically, it is a quasi-judiciary authority. They'll not be bound by Code of Civil Procedure 1908, wherein high courts are bounded by the same. They'll have a similar power like a civil court, and they can also requisition, ask for public records, issue commissions for witness examination, dismiss or decide representations for defaults, etc. Purposefully, we are not going more in depth in the relevant sections and rules for the GSTAT because those are just on operational level. So we need not deliberate more on the same. It's all as self-explanatory. Other more relevant vital topics have been taken up and chosen for today's session. And our session is just of 1 hour and 15 minutes, a brief session, but it will be a good value addition for all of us. Application, the form is APL 05. It needs to be applied within 3 months on getting the order sorted. At present, the appellate is not functional. So once it's functional, and the other condition is once the president takes charge, 6 months from there, we need to apply for the first appeal orders, wherein we wish to go to the second appellate. GST appeal fees, the pre-deposit would be 20% of the disputed tax amount. Will all appeals be accepted? There are some conditions and criteria. Tax demand dispute amount below 50,000 will not go to the tribunal level. Section 112 subsection 2 states the same. Moreover, apart from taxpayer, if revenue feels that the order is favoring the taxpayer and the department wants to go against that order, they have an option to go and reach the tribunal itself. There's certain time period of within 6 months from appeal date, order passing date, which can be extended more by 3 months. So friends, as discussed in the beginning, if we seek or if we find that we have got a favorable order, then that might not be end of that chapter. Department always and can go further to the next forum. So we need to be prepared for the same. And hence, as I mentioned, beginning from the first reply to our notice, all our submissions, all documentation will become more, will have more weightage once the case moves to next forum. Because all the submissions given earlier will have its own weightage to be taken into records with the next forum. The appeal process has been decided and known to be paperless in digitized format. New e-portal, just a second. Sorry. New e-portal will be ready before all benches becomes operational, and digitalization will help in streamlining the filing and the administration process of the GSTAT itself. Okay. Few reasons or conditions wherein the appeal might not be entertained. At present, practically, which are the reasons wherein the appeals are not admitted by CESTAT? We are having a look at that. As CESTAT also has its manual and rule book, same way GSTAT will also come out with the same. But more or less, the precedents, the fundamentals will remain the same. So let's have a look at the reasons wherein the appeal may not be admitted. Limitation period, we all are aware. Condonation of delay also is possible. Jurisdiction issues, if the matter is falling outside the jurisdiction of CESTAT, appeal may not be admitted. Pre-deposit requirement, if a certain percentage as required is not paid, and failure to comply with the requirement can result in non-admission. Non-compliance with procedures. There are certain rules, certain procedures, certain forms and documentations necessary to file the appeal. So it needs to be complete in toto, then only the appeal with tribunals might be accepted. Inadequate grounds. If the grounds of appeal are found to be petty, not substantial enough to warrant a re-examination, then having a look at the order and the submission itself from the order, CESTAT may have authority to dismiss the appeal before accepting the C. Lack of authorization, some missing or some lacuna in the documentation structure, deficiency of fee payments which has been mentioned and required. So friends, these are some of the reasons wherein your appeal may be rejected. So we need to be aware and see that our appeal gets admitted at the first instance, because that is the primarily and the first step towards getting a fair and just trial with the higher. Okay. Provisions versus rules. We've been listening, having debate a lot of times over many issues under GST at present. Will rule overpower the provision or provision overpowers the rules, and what is the inter-se connection between them? So friends, as we are aware, provision is a specific clause with statute or regulation that stipulates a requirement, condition or stipulation, and rules are like detailed guidelines which govern, which will show you how the provisions needs to be implemented or followed. So provision will always be like the king. Rules will be in form of their subordinates. So rules will always come secondarily and provisions are primary. In legal context, there are instances where something may be mentioned in provision but not explicitly detailed in rules and vice versa. In case of ambiguity, at times courts do step in, and there are various case laws provided giving insights on how these interpretations are made. But in a nutshell, for a summary, provisions will always prevail. Let's have a look at a couple of case laws for the same. In Suraj Lamp and Industries, Supreme Court had dealt with such interpretation under Registration Act, and the Apex Court emphasized that statutory provisions must prevail in case of conflict with subordinate rules. In second example itself, CAT versus Anjum M. Gaswala, court held that in case of inconsistency, the statutory provision will only prevail. But friends, to get such an order or judgment, at times we need to move to the higher forum itself. At the first or second step, it may be difficult to get a ruling or judgment wherein they've clearly mentioned what will empower over which substance. Some principles of statutory interpretation: literal rule, golden rule, mischief rule. There are three more also, but as today is not the topic on interpretation, we'll just skip it and move on. Friends, these rules comes handy when there is lack of clarity, ambiguity, or contrast between or conflicting between two sections or two statements in the same law. So where the court needs to take a judgment, these are the general rules of interpretation which have been carved out over a period of time, and the courts seeking aid of this interpretation tools and rules, they decide and give judgment on the same. Literal rule says if words of statute are clear and unambiguous, then we need to follow them. They should be given their ordinary meaning. Golden rule says if in the first rule leads to absurdity, courts can modify the meaning to avoid the absurdity. Mischief rule says court will look at the mischief, that is the problem which has been there in the statute, and to mitigate the same, court will interpret the provision in a way that the problem will get suppressed. Section 1071 empowers any aggrieved person to move to appellate authority against any decision or order passed, and the time limit prescribed is 3 months from the date of communication or receipt of such appeal order. It's the same person may go for tribunal. Doctrine of judicial precedents. Friends, here we will discuss regarding the hierarchy and the weightage of orders and judgments given by Tribunal, High Court and Supreme Court itself. Please understand, the judgment which a tribunal gives, technically it is named and called as an order. And as we all are aware, High Court and Supreme Court, the order which they give, they are named as judgments, the final verdict. Now, first rule says, court which is low in hierarchy is completely bound by decisions of the court which are above it. Means to say, the low court, session courts, district courts, high courts, similarly. High courts are bound in their own decision in general, in matters related to precedents. So in one of the case, if the High Court has given a X judgment, then deciding the Y case, the same High Court are bound by their own decision and to see the ruling, the precedent given in X judgment, only if all the facts are same or similar or matching in totality. The decisions of High Court are binding on all subordinate courts. In case of conflict between two benches of similar authority, that is High Court, the later decision is to be followed. At times, if it is a single bench judgment, then a larger bench may decide on the same case, and the higher number of judges on a bench, that judgment will prevail from next onwards. Important to note, decision of one High Court of a state is not binding on other High Courts. The judgment of that High Court has a binding in that particular jurisdictional state itself. So tribunals, revenue officers of that same state need to be bound by that judgment of their home state. Supreme Court, Apex Court is the highest authority and its decisions are binding on all courts of the country. Excuse me. Article 141 states all courts are legally bound to the Supreme Court on their judicial decisions, but with the exception to Supreme Court itself. So Supreme Court is not bound by its own decision. However, they will recognize the earlier decision and wherein they may not usually deviate from, except if the circumstances are changed. For example, if an earlier decision is found to be incorrect, the Supreme Court may deviate from the same. Judgment is defined and stated as, under Civil Procedure Code, statement given by the judge on grounds of a decree or order. And the judgment given by tribunal are called orders. Friends, next, now we are moving on to another important topic of drafting. What is drafting? How to draft the submission, the paper book for applying to the appellate authority tribunals. But friends, before we move on, I've taken a separate slide which is different from, not in line of our today's technical topic, but it's important to discuss it over here because without this tool, what all we learn, we may not be able to practically implement the same. And the opportunities coming up in the taxation litigation arena after GST may not be utilized by we professionals to the fullest. Why is it so? We all have gathered over here to discuss and share something more about GSTAT and litigation arena. But friends, please bear in mind, each professional was once an amateur. It is relevant in all professions field of the world, also in the sports world. So we need to keep this point in mind, stating that if someone can do it, if I'm doing it, then my dear friend, you can also do it. To step into the taxation litigation arena, first and foremost thing which we require is the approach, attitude, and the mindset. The belief that we can learn it. In the words of Jim Rohn, international motivational speaker, all skills are learnable. And there is nothing called natural gift in the same. Of course, there is something like a natural gift, but it may not be having so much weightage or relevancy over here. So friends, first, we need to believe in ourselves. This belief is also required when we want to apply to first appellate or second appellate authority. That belief which is required at the second stage is just not for in ourselves, but in the case which has come up, and we believe that the order can come in favor when we go to the next forum. So friends, the slide over here is, it's all in your mind. If we think, if we believe we can do it, we can do it, and we can also go and present ourselves at the tribunals. Many of us might not have got an opportunity or chance or remain present with ICAI or CESTAT tribunals. But now this new opportunity with GSTAT is coming up. And believe me, friends, it is not so difficult or hard to prepare, make submissions, and have a hearing and appear with the tribunals himself. It says drafting is not an art, but there's a degree of science as well. Drafting is something creative like writing, but it has many disciplines to be followed, many do's and don'ts, which are coming up in the next slides. So we'll have a walk through over it. It is similar to writing. So friends, while we're preparing submission for first appeals, second appeals, what are the points which we need to keep in mind while we are preparing the submissions, drafting the matters? Usage of clear and straightforward language, effectively explain and break down complex legal matters. Friends, first and foremost thing is that the length or the size of our submission is not important. It is well said that if we cannot explain a point in few lines, then we cannot explain it also over in 2 or 3 pages. Meaning thereby to say, जो चीज हम 2-3 लाइन एक शॉर्ट पैराग्राफ में नहीं कन्वे कर सकते हैं, उस पे 2-3 पेज लिख के भी वो चीज कन्वे नहीं कर पाएंगे. And friends, once we move to the higher forums, we all might have experienced, known or heard and seen. Things move quicker. We need to be agile. Our submissions need to be precise and crux in the aspect that just on referring the summary or the synopsis or the executive summary, the reader, the other party will get a whole idea of what are the facts, what are the points at dispute, what is the main core question in this appeal or this matter, and what are your submissions therein. We'll have a look at it step by step as we go on. Prioritize reader's understanding and perspective. We need to write for ourselves, but keeping the reader in mind, the appellate authority, the bench member, and also the revenue department officer, because they will also be reading the same and coming up with the counter arguments. Focus on the writer's viewpoint. What is our main viewpoint? Follow 3 steps: planning, execution, and review. With paucity of time, some of the pointers are self-explanatory, so we are just moving ahead. There are much more material to be discussed and shared with you, many other topics over here. The ABCs of legal drafting. Accuracy in which aspects? Friends, please note and understand that the law is in the language itself. The words, the phrases, the sentences, and the language. Law uske andar hai. So, while we are drafting, we need to keep that aspect in mind. It's mentioned that the language is important, the content and the grammar itself. B stands for brevity. As I mentioned, in crux, avoid repetition, use minimum words. Please avoid using more of jargons, Latin phrases if not required. Next stands for clarity. To the point. I'm recalled of one of the movie scene of the famous movie 3 Idiots, wherein the college sir has punished Amir Khan and he requests him to move out of the class. And just before that incident, Amir steps in and he gives a long definition of the calculator. Then the sir gets balked up, and in the end he says, "आखिर में कहना क्या चाहते हो?" So friends, this point is very important. Anyone having a quick read, quick reference to a paper book submission, they should get the main idea, the main matter at aspect, and the facts of the case. Basics and checklist before drafting. Drafting appeals is a skillful practice. Verify if the appeal is applicable. Refrain from filing unnecessary appeals. Determine the time frame in which the appeal must be filed. Please start your paperwork submission beforehand, because when the due date is near, it approaches, the quality, the required output goes for a toss, and which might not come as a favorable outcome at a later date. You can appeal a penalty even if you don't appeal the assessment order, the tax demand. Sorry. Check if any claims were missed, if new pleas can be introduced. Ensure any missed claims, arguments which are not taken up earlier till now can be brought up as new arguments. Also check out on the technical, the merits side, wherein the authority issuing the order had the proper jurisdiction or not. The appeal order was issued within the allowed time frame. That is, please ensure the limitation period aspect as well. Next, do's and don'ts. We'll quickly go through the same. Keep grounds clear, concise, simple, free of ambiguity. Always include a prayer with specific requests at the end. Ensure grounds are broad and not restrictive. Use plain, simple language. Determine the order of priority of the grounds on which the points which we want to appeal against, appeal for. Review the order to identify any hidden grounds. Do mention if opportunity of heard was not provided earlier. Friends, as we all are aware, under principles of natural justice, a right to opportunity to be heard and given is compulsory. The taxpayer may need not ask for the same. The onus is on the revenue and the department to give you opportunity for hearing, unless if said and required and taxpayer has given mentioning in writing that in this case I do not want the opportunity of hearing, then and then only the revenue may not give you opportunity for hearing. One more aspect over here, friends, that if in case of a taxpayer, three notices, three matters are going on, then if the taxpayer has given the withdrawal for personal hearing in just one of the matter, then this withdrawal of personal hearing will be applicable only to that matter. For other two matters, the right of personal hearing is always there. It is the onus is on the department to give you the opportunity of hearing. Don'ts: avoid listing multiple grounds for single issue. Refrain from using lengthy sentences. Do not be argumentative. Place your points in a simple, lucid manner. Firstly, state the facts clearly, then plea on the grounds on the aspects, the questioning matter. Give references, judicial precedents only and only if the same facts are relevant. Also check that the precedent or the ruling which you have mentioned has not been overturned later on. Do not include decisions in grounds unless they are essential. Something else to be considered and discussed. Friends, apart from the main matter, facts, arguments, provisions, rules, some board circulars to be mentioned. Different kinds of grounds which the plea which can be taken is technical grounds, wherein, as we mentioned, limitation, merits, opportunity, as described earlier, was not given. Jurisdictional grounds, jurisdictional authority of which the previous order was made. Natural justice grounds, there are many points which can get covered under this aspect. Legal grounds based on merits of the case. Alternate grounds or without prejudice grounds. Friends, alternate grounds in the sense, to give you one example, if in a case, say for a transaction, the department is alleging that it is a deemed supply and GST needs to be paid. You have placed your submission and other things. One more plea and stand you can take. In case notwithstanding to anything mentioned above, in case the supply becomes taxable, then to consider the come tax demand aspect. I mean, the gross receipts which is there, it needs to be assumed that it is inclusive of tax. So at least you'll be saying 12 or 18% of the tax amount, because this is a concept and the plea which needs to be taken and is also allowed by the higher forums. Consequential grounds, if what department is alleging is to what next can be done, how it will impact to the present and future business. Additional grounds, if some points from plea has not been taken in the earlier submissions as well, then a request can be made to submit this additional ground. This request, tribunal has the authority to have a hearing itself, for this miscellaneous application needs to be made. have a hearing on itself, and then the bench decides whether they will accept these additional grounds or not. Some more pointers on drafting submissions. These are a couple of slides. For paucity of time, we will move on. You should be well versed with the orders, general facts of the case. Friends, with facts, the important aspect lies that we think and feel and practically know and understand that a client will not or may not know all the facts the way he or she should tell us, or the way we require it to be submitted in writing in our submissions or the paperbook. Meaning thereby to say, हमें लगता है कि हमारे क्लाइंट को सब फैक्ट्स पता है या उसने जो बोला वो ही फैक्ट है, काफी बार वो जरूरी नहीं होता है. To give a practical example, when having consulting meetings with new clients on litigation aspects, I've seen at the end of second meeting, they come up and speak up that, sir, on this same matter for which the notice order is issued at present, 1.5 years back, a search had undertaken or taken place. Now, these all are very vital and important points when deciding the litigation strategy and to ensure the facts of the case and how to give submission and how to move forward with the matter. So such important aspects clients may tend to forget, they may not realize, they may not spill out in the first or second meetings. At times we get to know more things from their finance heads and accountants rather than the owners or the core management. And what are facts? There are some few slides. We'll quickly go through this and then we'll discuss more on the same. Belief. First, the consular needs to believe that his case is strong or what the taxpayer demands is legitimate, possible under the four corners of the law. अगर उस चीज में हमको विश्वास नहीं हो तो फ्रेंड्स आप किसी और को विश्वास नहीं दिला पाएंगे. So firstly, we need to digest, assume or give our own call or own decision whether this matter can be taken up or it is practically possible or what is the opportunity cost to take it up. I'm happy to see some Q&A coming up. Couple of more technical aspects are forward. I'm just skipping a couple of slides. New facts we have discussed, highlight the summary arguments, strongest to weakest. This is not related to GSTAT, but it is based on which we are getting notices and orders under GST. Inquiry, assessment, audit, investigation, special audit, any other source. Wrongly availed credit but not utilized, reversed through ITC, argue on the base that it is availed but not utilized. Drafting, last slides on drafting. It is a skill, art, knowledge of multiple laws, a 360-degree overview of the subject matter is very helpful. Friends, one more aspect I'm recalling. As we're discussing for the first appeal, second appeals and GSTAT tribunals, one more topic which is a good resource and for those interested further can have hands-on. There are topics on art of judgment writing. What is the basis on which the high courts prepare the judgments and the orders? What is the science, what is the logic which goes behind giving the judgments? So friends, when we want to fight a case from the side and point view of the taxpayer, when we want to get a favorable order or judgment for the taxpayer, what is the psychology, logic behind drafting the judgments? If we know that, then we will be having one step further know-how, and we can be very well adversed and see how to give our submissions so that the end result can be met and we can put up a case strongly and our clients can get a fair and equal chance. Just try. Language, maintain timelines of events, analytical skill. Think about counter questions coming up. What the departmental revenue officer side will do. Think about that. Be prepared on the same content in itself. So in less hearings, your case, your matter can be discussed and order may be passed. A well-organized law typically begins with statement of what the law is, what it does, and what it covers. Explicit or implicit cross-references must be clearly mentioned. Logical interpretation amongst provisions are integrated is very important. Friends, will move on for 10 more minutes. Couple of important slides of evidence act I have taken. I'll also wish to discuss on the same, and then we'll open up the forum for Q&A. I hope you are enjoying with us today evening. Yeah, procedures established by law. We'll quickly go through the same. Friends, it is an old concept in law wherein no man of what state or condition be brought out to punish without following the due process of law. So even under GST, there are so many forms and procedure and structure issued. An order cannot be passed right away without following the due process of law. Whatever tax is being charged has to be backed by law passed by legislature or parliament. Litigation, the word lis is a Latin word from which the litigation word has come up. Natural justice. This is another important topic on which till now most of us feel that orders or judgments can be one of can come up in favor of taxpayer only if the provisions or the rules of the act are in favor of the taxpayer. But friends, it is just not so. There are many different aspects wherein if which are known, which are studied, then we can do much more favor for taxpayers and we can get favorable orders wherein earlier we had thought that there is not a strong case to put forward. No one should be a judge in his own case. Nemo judex in causa sua. So similar aspect under departmental GST audit, as we know, once the final report is issued, the same goes to the adjudicating officer. Then under 7374, the adjudicating process begins. And on the observations and for which the DRC 3 is not been filed up by the taxpayer, the proceedings take forward. Audi alternate partem to hear the other party. Legal framework, what it says, read the order first. Many of the senior colleagues have recommended and have shared order before they start their drafting or the submission aspects. They are reading it more than 10 times. Yes, you heard it right. More than 10 times. I mentioned ignore the contents. Ignore the contents for first reading. Friends, this is more not just for the order, but more important for the notices. Because under notice, if you see, if we quickly rush to the heart, main content of the notice, we will be blinded to seek other aspects, other technical parameters of the notice and check out for the follies of the notice in itself regarding to timeline, jurisdiction, authority, other aspects. Proper prescribed form, notice has been issued in under proper prescribed form or not. Defects in notice is fatal to demand. It cannot be sustained. So even in case of order, we need to see the series of notices which have been come up. And as I mentioned earlier, the first reply of notice is important because of the section 160 subsection 2. So that needs to be strike a balance between the first reply and the last reply. This will skip up. A recent case law had come up wherein ITT Mumbai had condoned a delay of more than 2200 days. So friends, it is not so. If you think that इतने साल चलेंगे अभी कौन सुनेगा ये केस लेके क्या करेंगे, but if you have passion, if you find out a proper legal way out, then there is a way, there is a scope under taxation litigation arena. And this is a splendid example of the same. I'm skipping up few slides. Yeah. Evidence Act. Indian Evidence Act 1872 is still valid till this month. From next month, the new amended Bharatiya Shastra Act will come into play. But as far as this 6 to 7 years of GST are concerned, this Evidence Act is into play and it will apply. We'll take up this slide and then we may stop for the Q&A session. It's just about to be 6. Friends, what are facts? Facts are statements which it's not required to be proved. For example, taxpayer is a registered person. Taxpayer is not under composition scheme. Taxpayer has duly filed his or her or their GST returns. Taxpayer has timely filed the annual returns, so on and henceforth. So there are few aspects wherein both the parties agree and there is no ambiguity or question mark in the same. These are facts. The word says proved facts which need not to be proved, they are evident. Disproved means they are evident that these are not facts, these are not legitimate or ideal statements. Not proved. Not proved is the aspect wherein in between, which cannot be proved, which cannot be disproved. Means it is not there or it is not here. That word is called not proved. Undisputed allegations. Friends, undisputed allegations does not require proof. So we need to take care on the aspect of onus and burden of proof when new additional information is being shared during the course of a proceeding. The onus and burden of proof shift from revenue to the taxpayer, to the person entering this new additional information. Section 50 states facts admitted did not be proved. Section 101, burden of proof. A person is bound to prove the existence of any fact. It is said that a burden of proof lies on that person itself. New material, if we introduce, the onus falls on the person introducing the new material. Next, person making allegation needs to prove. For example, department alleges that rate of a certain product should be 18% and instead of 12. Then the onus shifts on the department to prove that why it should be taxed at 18 and not at 12. Some established rules of natural justice, which we all need to pay heed and understand. And this all pointers can become a strong point for a submission on case-to-case basis. Article 14, equality in general. Friends, hereby I am reminded that the main law of the land, the Constitution of India, is very important because many of the concepts, some procedures, some articles which are there, as many high courts have ruled in favor of taxpayers just on basis of this rights and articles under Constitution of India. Article 14, equality in general. 21, guarantee to life and liberty. Right to adequate notice. Right to hearing. We already discussed. Adjournment. Yes, the taxpayer can seek at the max 3 adjournments. It's the same also in case of tribunals and also under adjudicating procedure. Right to rebut adverse evidence, right to legal representation, reasoned decision, the order decision which comes up, it needs to have its own reasoning in itself. Next, violation of natural justice. Couple of brief case laws and examples just to understand. In case of Finopatec Limited, it happened that SSA changed their address on portal twice, but show cause notice was sent to old address. The order was quashed by the Mumbai High Court. This is the recent judgment. The landmark famous judgment of Menka Gandhi versus Union of India, wherein the apex court had mentioned this and gave more importance to articles and rights of the citizen. In this case, it had happened that the ministry had suspended and cancelled Menka Gandhi's passport. And on asking, they didn't give any written reasoning or explanation behind the same. So the matter went up to the apex court and it was ruled out. And it was mentioned that due process of law and procedure as established by law needs to be followed under each and every act. I mean, it is just not based to taxation aspect as well, but these are very vital in taxation also. Some practical tips, some more discussion, but now time is short. I'll just brief up. As the organizers team have already mentioned, we'll get the PDF PPT to all the participants. Last aspect regarding golden opportunity, we have already discussed the number of benches, the way the cases are being come up, notices, orders, moving to first appeals and then pending going to second appeals. So friends, there is ample of opportunity, and along with GST, other resources, other topics which I described, art of judgment writing, knowledge of allied laws, some brief about different aspects, the way and means to know the correct facts of the case. This all are very important. Although in today's brief session, I could just touch upon few of the important aspects wherein if we pursue and study further, it can help us in our litigation arena field. Some more miscellaneous points, but now we will take up the Q&A. If anyone have any questions, you can put up in the chat. Yes, everyone will be getting the PPT. Any questions? Organizing team can if take it further. Yeah, presentation will be given. How to grow litigation practice. Friends, this is a very, I would say, $1 million question. Few pointers or tips which I can share from my experience would be to place it. There are three aspects to it. First, knowledge domain. Second, sharing of that knowledge. Third, purpose. The purpose, with the word first, I'll take up the purpose one, which is more important. With the purpose, my question is not related that why you want to go into the litigation practice, but the purpose we need to identify should not be just to mint or make more money, but the purpose should be related to the passion or something higher than money. For example, if you, whenever you meet any of your client and you ask that why are you into this business or why are you into this service or industry, 90% of the cases they'll just have one answer, that I'm here to make money, make profits, so that I can have a good luxurious life and my family can have the same. Friends, money should be at the second criteria. If we make the aim or the purpose to serve the clients with some different concept, then there'll be a paradigm shift in our thinking, and money will come, it ought to come, but we need to firstly shift our focus, and that's why I mentioned purpose. Second point, sharing of knowledge. There are many means and ways, various posts, articles, becoming a speaker, taking up webinars, sessions, attending conferences, RRCs on your favorite topic, on your passionate subject. First, domain knowledge. In today's digital world, there's nothing more to speak about knowledge. There are many resources, online, offline modes to seek knowledge, learn, and grow. Of course, to grow the litigation practice cannot become overnight. It is a journey, it is a process in itself. Because by litigation, we mean specialization. And as we all know, specialization takes its own time. So, yes, we can plan, make up some goals, and move forward in this journey. And it will be a great and exciting journey, which I can say from my experience. Yes, any other questions, please? Yeah, there are a few more. Just a second. The tab is not coming. Yeah, I'm taking up other questions. Is the first appeal with commissioner appeals in online faceless mode or personal hearing? At present, under GST, personal hearing is there. At the times of COVID, online virtual mode was also there. Qualification at present, professionals, CA and advocates, and I guess CS also would be allowed. So these are the professional qualifications. Also, employee of the organization, relative of the organization, they can appear as a representative, which is the requirement under CESTAT.